I'm the Director of Product Marketing at Replicon. Replicon is the leader of cloud-based time tracking applications. We have over 7,800 customers worldwide, and we help address many different types of time tracking needs, including time and attendance and labor compliance. And Replicon is pleased to sponsor today's webinar on the topic of understanding work time. And we're very happy to have Brian Dixon of Littler Law Firm join us to present today's webinar. This is the second of 6 webinars of our compliance series. Last month, Brian presented a great webinar on contingent labor and provided attendees guidance on how to determine whether someone should be classified as an employee or not. Now, once an organization has figured that out, they have to figure out whether someone who's employed, the next question is, well, what time should they be paid for? In other words, what constitutes work time? And that's going to be the focus of today's webinar. And we're fortunate to have Brian here to help us sort through all that. Now, before we get started, I wanted to review a few housekeeping items. So first, I'd like to let you know how you can participate in today's webinar. During the webinar, you'll be kept on mute for the presentation, but you can submit your questions at any time using the presentation questions box that's located at the right-hand panel of your screen. Then we'll be addressing all questions at the end of the webinar. And secondly, I'd like to remind everyone that you are eligible to receive HRCI credit for attending this webinar. You'll be receiving an email with certification information. Do please stay on for the complete webinar in order to receive the credit. So now, let me go ahead and introduce our speaker so that we can get started with our program. So as I mentioned, our speaker today is Brian Dixon. Brian Dixon is a shareholder in Littler's San Francisco office and the co-chair of the firm's nationwide wage and hour practice group. Mr. Dixon is a graduate of the Stanford University School of Law and has served on a wage board for the California's Industrial Welfare Commission. Mr. Dixon provides a full range of counsel and representation with respect to employment and labor matters. His particular expertise is disputes regarding minimum wages, overtime, prevailing wages, and incentive compensation. Mr. Dixon is the author of the Federal Wage and Hour Laws published by Shoreham and the general editor of the Wage and Hour Answer Book. He is a contributing author to the Fair Labor Standards Act and Wage and Hour Laws, a state-by-state survey published by the ABA, and California Wage and Hour Law and Litigation, published by the California Bar Association. So without further ado, I'd like to go ahead and turn it over to Brian and have him present this topic to us today. Thank you, Brian.
Thanks very much, Armando. I appreciate the introduction, and I always enjoy working with all of you at Replicon and the fine solutions that you provide for employers when they need to find solutions for timekeeping, especially in today's challenging era of wage and hour litigation. And I'd like to start with a small cautionary note. We're going to talk about both federal law and state law, and we are going to cover quite a few subjects very quickly. So I would hope and I would ask for your indulgence if we don't get a precise answer to every question you might have. I'd invite you to send your questions in so that we can get them answered for you, and if we can't get them answered during the program, we will get them answered shortly thereafter. We are going to talk about federal law, the Fair Labor Standards Act, passed in 1938. The FLSA has few very general concepts that give you across-the-board answers. We'll talk a little bit about general concepts today and then more particular application of those concepts. The Fair Labor Standards Act is nicknamed by those of us who deal with it regularly sometimes as forever lost seeking answers. So it is a good idea to approach the subject with a certain amount of modesty, shall I say. Let's go on and talk about what our agenda will be for today. And that agenda includes talking about what is work time, and it includes looking at state concepts as to work time. And as I noted a minute ago, there's a little bit of a gap between the general concepts and the application of those concepts to a particular set of circumstances, and the result is what I would call a little bit of a cookbook approach to what is work time. And so we'll go through some general concepts and then talk about their application. And I'll pose a question now that's sort of just food for thought. There is no precise answer that I know to that question, but let's think about someone who goes to open enrollment or goes through the open enrollment process. We've worked very hard in HR and benefits to get that worked out. We have a nice web portal. It lists the benefit plans. They're your options, and you can, of course, perhaps we have a cafeteria plan and you can opt out, or if you don't attend open enrollment, then you just forego the benefits. And, on one bright and sunny Monday morning, one of the employees comes in, a non-exempt employee, and says, oh, by the way, I enrolled. I thought the web portal was great. I read every benefit plan from beginning to end. It took me 16 hours, 8 on Saturday and on Sunday, and I'm about to put them in on my time card. Okay, and you're sitting there going, there must be something wrong with this. So we'll come back in a few minutes, and we'll talk about how the general principles might apply to the providing an answer to that question. So let's take a look at our next slide and what is work time. And of course, we face a challenge under federal law, and that is that Congress did indulge us in 1938, passed the Fair Labor Standards Act. That act actually has several purposes. One is to provide an incentive for an individual employee not to work so many hours. It also had by the way of imposing overtime, and overtime also has a public purpose in the sense that it's intended to spread employment through the community. 1938, of course, was the worst year of the Great American Depression, and you can see those dual purposes at work. Well, the funny thing about the Fair Labor Standards Act is it's all about work. The minimum wage is measured by work. Overtime is measured by work, but there's no definition of work. So this small issue, shall I say, eventually wound its way to the Supreme Court in the mid-1940s, and after a great deal of struggle, they came up with at least a verbal formula for work. It's mental or physical effort controlled by or primarily for the benefit of the employer, whether burdensome or not. And we can stop and think about that and say, it sure sounds like work. But it's interesting to see that there are a couple things that aren't there. One of them is that work time can be voluntary. There's nothing here that says it's compelled. And the other thing, of course, it could be, as hopefully this webinar is, enjoyable. And that is you can actually enjoy your work. There's nothing about the notion that it is burdensome, or not, allows us to enjoy the work that we do. And if we go back and we start thinking a little bit about our question of open enrollment, we might ask ourselves, is there an element of work there? And of course, if we were doing a good job of putting together our web portal, there were probably pop-ups on each individual computer screen that said you've got 3 days, 6 hours, and 27 minutes and 10 seconds left to complete the open enrollment process. And one might say that one is required at least to go through the web portal. But, is reading all of those benefit plans really for the benefit of the employer, or is that primarily for the benefit of the employee? And while there's no precise answer to this question, I think we can probably say that reading the benefit plans from end to end, especially over the weekend outside the regular workday, would be considered primarily for the employee's benefit. And I don't think you'd have to buy into all of those 16 hours of work time. Maybe the amount of time, perhaps 15 minutes, that it takes for an employee to go through and check the boxes necessary to continue benefits, as you probably have an expectation that the employee will in fact do so. So let's continue and look at our next slide and talk about work time in a little more detail. Work, as we discussed a minute ago, can be voluntary. Work actually is that work which an employer suffers or permits, and we know what permits means. We know that permits means I authorize it, but let's look at two really important scenarios. One is the supervisor in perhaps a very conventional work environment has a desk at the front of the room, and all of the desks of the employees in the department face the supervisor. The employees are sitting there diligently working away, 5 p.m., the workday ends, and most of those employees get up and leave, and the supervisor smiles at them. 2 or 3 of the employees who tend to sit towards the front of the room continue working, and the supervisor smiles at them as well because he knows they are his or her hardest workers. He also or she also knows that all of those employees have been informed that there's no overtime unless it's authorized in advance. And, of course, there was no authorization for overtime this afternoon. And the employees are working away, and the supervisor is also pleased that this little extra effort, which gets them good evaluations every year, doesn't appear on their timesheets. We have a work time issue. Well, we do. We have suffered work. We knew or should have known that that work has been performed, and that's what suffer means. We knew it was being performed, and it leads us to the corollary that if you don't want to pay for it, you have to affirmatively stop it. You run into the same scenario if, for example, the supervisor were to ask one of those employees, hey, I need this report typed up by 8 a.m. tomorrow morning, and by the way, you know we're already over the overtime budget for the department for this month. Smile, smile. It doesn't show up on the time card. Well, that didn't get done by magic. I'm sure the employee would have thought waving a magic wand at that stack of paper would have gotten the report completed, but it didn't, and we have work time in that case as well, because even though we didn't observe it, we should have known that it was occurring. So let's go on and take a little bit further look about work time and one of the underlying federal concepts here in our next slide, which is all about what I call the continuous workday. In the 1940s, there were a number of really seminal Supreme Court decisions about work. The first one we talked about was just coming up with a definition of work. And a companion case dealt with when does the workday begin, and do you have to pay an employee, for example, who works in a factory, from when they drive into the parking lot, when they park the car, when they get out of the car, when they walk through the factory gate, when they get to their workstation, all became a question. And the Supreme Court decided that pretty much when you walk through the door, you should be paid, and employers certainly took some umbrage to that, and they persuaded Congress to come up with what's known as the Portal-to-Portal Pay Act, which is a very important supplement to the Fair Labor Standards Act, or Forever Lost Seeking Answers Act. And basically, the Portal-to-Portal Act divides an employee's activities into principal activities, for which an employee has to pay, the employer must pay, and preliminary and post-preliminary activities, which could occur before the beginning of the workday or after the end of the workday. And the important concept here under the federal overtime law that applies to in every state is that once the first principal activity of the day begins, then everything else, whether you might think it's preliminary or post-preliminary, is work until the end of the workday. You might notice that while we've made some progress in the sense that Congress has addressed the issue, there is certainly a fair amount of circularity in Congress's proposed solution. So what we have are principal activities, which are integral and indispensable to an employee's work, and preliminary and post-preliminary activities, which are activities that are not principal and also occur before and after the beginning of the usual workday. So we want to bear all of these things in mind, and of course, if there's no other takeaway from today's program, and if you happen to be a Scrabble player, you might add post-preliminary to your vocabulary, your repertoire of playing words. You'll probably get challenged for using it, but then you can double up and prove that it exists, and away you go. How might we apply this concept in a really simple way? Think about employees who work at an airport, and like everyone else who goes to an airport these days, they have to walk through the security gate. And what if an employee says, hey, my workday should start at the security gate? Like everybody else, I have to wait in line. Waiting in line is not fun. It consumes part of my day. I have to do it because I can't get to work otherwise. And the courts that have looked at that have actually said, security at an airport is, in a sense, indispensable to doing your job, but it's not integral to the job. Anybody who goes to the airport has to go through the security gate, whether you're a passenger or a worker at the airport, so we won't call that work time. Let's look at a small variation on that. One of my colleagues represented an electronics retailer which has a bag check as employees leave work every day, just in case one of the shiny and appealing objects that the employees sell should accidentally fall into a backpack or a handbag or a briefcase that could be recovered on the way out. And there again, there's waiting in line, and the question becomes, is that waiting in line work time? There, the Court of Appeals said, you know, that's really more not only indispensable but also integral in the sense that the employer's requirement that security be maintained. And just to prove that that actually is a very close question, just last week the Supreme Court decided it would accept review of that decision, which tells us that the line at which work begins, the beginning of the day and the end of the day, is in fact a fairly blurry line, and one has to be mindful of that as a potential source of dispute. So let's go on and recap in the next slide our key concepts, and they are these. Work is work can be divided into two large groups: principal activities, those that are preliminary to the workday, those that are post-preliminary to the workday, that are not integral and indispensable. If we look at these, booting up and turning on and off the computer would be integral to an employee's job. And while it may be only a few minutes, any activity that is regularly repeated is, at least in the Department of Labor's view, not de minimis and has to be counted as work time. Reading work-related emails, say you may need to do that before your shift starts in a call center. Shift change conversations, this is something that I run into as a recurring issue with employers that have continuous operations, and they schedule their shifts for 8 hours, and they pay an employee for 8 hours, and somehow the magic of I must have learned by osmosis what happened on the prior shift and what the status of the plant was. So we do need to have a little bit of latitude, osmosis being hard to come by as a communication device or communicate that information. Donning and doffing at workplace, if required, certainly is going to be work time. We'll come back and talk about it later. We have not work time, which is commuting, walking from the parking lot to the workstation, and waiting to punch in at a time clock. So if we proceed a little bit further in our program today, we will look at a recap of what our key concepts are. Work is broadly defined for the employer's benefit, the employee's benefit. Employees must be paid from whistle to whistle. That is the federal concept of the workday and activities, only preliminary and post-preliminary activities being excluded. Work includes any time the employee is required, requested, suffered, or permitted to work, and we need to stop work if we don't want it. Now, this actually is a very good point to say that we're no longer in the 1940s. We are in the decade of the 2010s, and technology has progressed. And technology poses a few challenges here because the concept of the workday breaks down a little bit when employees, for example, can start work at home by reading email. They may be field service technicians who go off to the first call of the day. They handle that call, go to call, go home, and perhaps upload a report. And there's been actually a fair amount of litigation around, well, if we apply the continuous workday literally, I should get paid from when I start my email in the morning until I do my upload at night. And in fact, there's one rather frightening case in Massachusetts involving an insurance company where the court decided just that. One of the interesting things about that case is that those insurance adjusters who would log in the morning, get their assignments for the day, drive off to find the first, distressed insured with a bent, hopefully nothing more than a bent bumper, were really expected to work from home. And they did a substantial amount of work at home, and they did their work in the morning and in the afternoon in direct proximity to their commute. I worked, I drove, I worked, I drove, I worked, I drove, I worked, I drove. But still a very sobering result. And not only for insurance adjusters in that scenario, but perhaps raising some questions for other telecommuters, and that is, if I work at home, but I have to drive to the office in the middle of the day once a week for our weekly meeting in office, in person, I actually see your face now, meeting, whether that's also work time. There are a few cases since then that have actually been a little bit of a salve to employers' concerns, and in those cases, employees who worked at home but who could decide when to work at home, who didn't do their work in close conjunction to their commute, who just uploaded data when needed, or when convenient for them in the morning or in the evening, were not found to be working continuously from the first increment of work in the day to the last in the afternoon. For example, if you look at a company called LoJack, which had field service technicians who installed little transponders that would tell you as the owner of car if the car wasn't at the curb when we opened the front door in the morning but had unfortunately been stolen, you might be able to figure out exactly which ship your car is on and where it's headed. And those individuals had to upload data in the evening, and the Court of Appeals decided, you know, we don't have to pay you for your commute home and all the time until you do the upload, because you choose when to do the upload. It's not done in conjunction with the commute, and the upload is fairly brief in time. So let's go on. We've taken a look at the key concepts. Let's go on and talk about the cookbook approach to hours worked, because we truly do have a cookbook to look at. And let's go on and look at another adjunct of work time, and that is meal and rest breaks, waiting time, on-call time, training and meeting time, travel time, pre- and post-shift activities, sleep time, grievances, suggestion systems, and charitable activities. We'll look at all of these things in our cookbook approach here. This is just our forward look to see what we'll talk about. And one of the things that is ubiquitous these days, if we take a look at the next slide, is when on-call time is work time. Oops, we have meal and rest breaks first. I guess we're going to have my mistake. And here we're going to talk about meal and rest breaks in the sense of when are they work. We're not going to talk about when they are required, which is a separate subject that we'll pick up in a later webinar. And the rules are relatively straightforward. You can have a meal period of 30 minutes is basically the minimum. There are very few exceptions to that. Most states that require meal periods require a meal period to be 30 minutes. I had a client in Oregon that got penalized rather severely by the state because a fair number of employees were punching back in after just 27 minutes of work. There was a jury decision against a major retailer here in the Bay Area where 27 minutes was sufficient to be a half-hour meal period. Everything has a certain amount of rounding factor to it, but anything less than 27 minutes was found to be work time. So we need to keep that in mind as a rule of thumb. There are some isolated exceptions. Illinois only requires a 20-minute meal period. Illinois is a go-go place to be working, but trying to have a 20-minute meal period that's not work time is a challenge under federal law. What about we come across someone who's sleeping at their desk? Well, that's certainly a rest period, but they only nod off for 5 minutes and they wake up again. Do we have to pay them for the time? Well, I would suggest that, yeah, you probably do have to pay them for their time because rest breaks of less than 20 minutes, and that individual is certainly resting well, are compensable work time, and perhaps your solution there is to cut the final paycheck and escort the person to the door so they can go home and go to bed and perhaps find new employment on the following day. But we do want to make sure that we realize that even short rest periods are compensable work time. We also want to appreciate, going back to meal periods for a moment, that there are a variety of requirements for meal periods as you look across the United States. On the state level, for a meal period not to be work time. So we're looking at the basic 30 minutes. You have to be relieved of all duty. Sometimes you come into issues because, for example, the members of a utility crew that are working at a job site might be required to maintain continuous surveillance of their equipment during their meal period, and under a very strict construction of some meal period rules, that might be work time. Certainly if you have employees, for example, security employees, or in the hospitality industry where it's very common for people to carry radios, or even in large retail stores you see individuals with radios and headsets. To be relieved of all duty certainly means that you unplug and turn off that radio during your meal period, or you risk having to pay for the meal period. And we have a few states that require you be able to that an employee be able to leave the premises during a meal period in order for that time not to be work time. For example, California requires that, and so does Nebraska, for a meal period not to be work time in Nebraska, you have to be able to step out of the front door and admire the beautiful golden cornfields of Nebraska and perhaps walk around the corner and admire some more beautiful cornfields in Nebraska. Let's talk about on-call time, which is a subject that has become more and more common as a subject of work time. And if we look at our next slide, we'll see that on-call time has several factors that are examined, and you find small variations between federal law and state law as to when on-call time is work time, but you'll see that generally the factors run the same across all of these cases, and there are many cases in on-call time. You look at how burdensome is the on-call time. Is it primarily spent for the benefit of the employer or the employee? You look at the frequency of calls, the response time, the duration of the calls is also a factor. If someone has to spend a lot of time on call, you might look at how long someone has to spend on call. Is it 24 hours a day, or is it just early in the evening and through the middle part of the weekend? And this is a very frequently litigated issue. The last time I deposed a plaintiff in an on-call case, the plaintiff complained bitterly that he could not go very far from the home that he lived in a small town in Southern California. He went on at great length about that. I thought about his bitter complaints for a period of time, and then I sent a request, equivalent of a subpoena, to his lawyer and asked for all of the employee's credit card records for the last 4 years. And the plaintiff's lawyer called me back and said, how do you like to settle this case? Because I think if we actually went through those credit card records, we discovered that the employee's circle of activities was probably a bit larger than those who generally complained. You do need to be mindful when you look at on-call time that employees will often tell you, I'd rather be on call than to be scheduled to work on a Saturday or scheduled to work on a Sunday or to have a staggered shift that starts at noon and goes till 8 in the evening or 9 in the evening. Please, please, please let me be on call. And an employer's best solution to on-call time issues when you're concerned about how far into the gray area are we, is to use the staggered schedule to provide your coverage. Employees won't like it, but we need to realize that you're much better off planning to provide coverage than you are to do anything in terms of indulging the employee and perhaps being sued at a later point in time. Closely related to the concept of on-call time is work time, and waiting time, excuse me. And if we look at our next slide, we can look at some of the issues here. So let's put ourselves in the position of an employee in a factory setting, and the production line goes down, there's a mechanical failure, the supervisor comes by and says, okay, everybody punch out, and you're sort of looking at the supervisor going, well, yeah, that's okay, a few minutes off would be fine, but do you know when we're going to start up again? No. Is there any precise time you'd like me to come back? No. We need to appreciate that if you create just a hole in the middle of the workday, you don't provide a specific return time, and the amount of time that's there is not sufficient for an employee to use for his or her own purposes, you'll wind up with a liability for work time. Good example of that is a trucking company in the Midwest where drivers would finish their routes. They were local delivery drivers. They would come back to the terminal, and the employer would say, I don't have anything for you right now. I might have something, I'll have something for you a little bit later. Hang around. Well, the court said unless you give an employee a specific return date and time, and you have at least 2 hours of time, in that case, the court pointed out that this terminal was outside of the city limits. There really wasn't anything that someone could do in less than a 2-hour period of time. Then you had to pay for that time, even though it wasn't productive. Let's go on and talk about training and meeting time. The same concepts are used to determine when both training and meeting time are work time. You can see them here on the slide. Let's think of a couple variations on this just for some interest. What about an employee who, again, our diligent employee, the one who actually read all the open enrollment plans, is knocking again on our door and is saying, I just here in the accounting department, I'm your favorite payroll clerk, and I have just finished a community college course in which I have carefully studied how to better prepare the spreadsheets that you like to see me do in the course of my job. And I forgot to put that on my time card, but it's been 2 hours every night, twice a week for the last 12 weeks. So I'm looking at 2 for 48 hours overtime. And here's my time card, and thanks very much. I'll look for the overtime in my paycheck. We might say, what's the matter here? And the employee's saying, well, I looked up the work time rules, and it was voluntary, I agreed. It was outside of regular working hours, I agreed. I didn't do any productive work while I was there, but, it's direct. I can do a better job here. And there's a very fine dividing line there where courses or training programs that meet all other 3 requirements, but which train an individual generally to be more efficient. You go to a community college, odds of being trained in exactly how the payroll department of ABC company likes its workflow to go are very, very limited. So we come to the first exception, which is training of a general nature, commensurate with that which would be acquired in a public school is not work time. So we're pretty good there. Let's say we're a police department in a very large urban setting, let's say in New York City, and we put on nifty training classes outside of regular work hours. They're voluntary. You don't do any productive work, but we train you so that you can rise through the ranks. And, for example, all the police sergeants can come to class and learn how to be lieutenants. And New York City, needless to say, got sued in a class action by sergeants, perhaps disappointed by the fact that they had not been promoted to being the lieutenant, have to be paid for that time. And the court said, this may incidentally make you more efficient in your job as a sergeant, but it's really oriented to making you a lieutenant, which is a position you don't have. And the court concluded that training for advancement is also an exception to this requirement. And there's a third exception that sometimes comes up. Let's say we're a registered nurse, and we are required by state law to maintain a license. It's my license. I went to school for it. I fought for it. I took that exam. I'm a overtime exempt professional in 49 states except in California. But I have to do continuing education courses to renew my license every few years. Does my employer have to pay me for that time because I'm employed as a nurse? The answer is no. You don't have to be paid for that time. That license belongs to the employee. It is the entry to the profession. On the other hand, if the employer is required to have employees go through certain training, the fact that that requirement is imposed by state law doesn't get the employer off the hook for the training time. Let's go on. Let's travel on, shall we say, and look at travel time as the subject of whether it's work time or not. And the basic rules are laid out here, but I think the important thing to understand about travel time is that while the rules are easy to master, they're easy to write down, their application is made very complex simply by virtue of the fact that travel is an unpredictable undertaking. You have delays, you have side trips, you have people leaving very early in the day and arriving late at night, and you have people who travel from time zone to time zone. Well, see, if I send everyone from the East Coast to the West Coast, could I really just cut those hours out of the workday, assuming that I never asked them to come back to the East Coast? And I always tell a client you're best off keeping travel time hours in constant home-based hours, which is really good. And I explained that patiently to a client a few years ago, and they said, that's great, Brian. We really appreciate that, but my employees are traveling from San Francisco to Singapore. So, and I said, that's great. Keep your time in constant San Francisco hours. And they said, what do we do about the international date line? I was tempted to say, we just sort of fold the timesheet in the middle, and you lay one day over the other. So we ran into a few challenges there, but we stuck to constant California hours. Travel, of course, from home to work is generally not work time. Travel from one work site to another work site is work time. The federal rule that you see here, travel on a special one-day trip outside of going out of town, you have to pay the excess of the travel over the normal commute. And suddenly, and this is one of those little mysteries of wage and hour law, if that one-day trip becomes a two-day trip and you stay overnight, then the time spent traveling as a passenger outside of regular work hours is not work time. The one challenge here is, again, we talked about it earlier, I won't revisit the subject. If I worked at home and then I traveled, is there an issue around, I traveled to the office, is there an issue around that commute time being work time because my workday has already started? Sensitive subject. Let's go ahead and take a look at our next slide. Talk about a state variation in travel. We need to realize that state laws can be broader than federal law, not just with who's exempt and not just with respect to what the minimum wage rate is, but also with the definition of what work time is. In both California and the District of Columbia, for example, consider all employer-required travel to be work time. You can, to a certain extent, avoid challenges there by paying a lower rate for that travel. But if, for example, you pay a lower rate and somebody has a lot of travel in a week, their paycheck might look a lot lower than what was expected. So you have to look pretty carefully before you use a dual rate pay plan. Let's go on and look at one other travel issue, and that is people who commute in employer-provided vehicles. This statute, the Employee Commuting Flexibility Act, which is on the next slide, was a result of a lawsuit in Chicago where Mr. Baker, an employee of GTE, sued GTE for travel time, even though he worked under a collective. He worked at home. He had a company vehicle. He didn't have to pay the gas to get to work. He drove directly to job sites. He saved time. There were fewer exhaust fumes. It was an environmentally sound program, as the judge explicitly noted. And the employer wondered, gee, what could be the problem here? Even the collective bargaining agreement under which this employee works says this is not work time. And the court said, we apply the suffer or permit standard. The employee travels to work carrying necessary tools and equipment. You have to pay for the time. Well, Congress undid that when GTE went to its legislators and enacted the Employee Commuting Flexibility Act, which basically says if you travel in a company vehicle, you travel in a normal commuting vehicle, not a heavy truck that requires extra attention. You travel within the normal commuting radius of the employer's operations, and the employee incurs no cost in the operation of the vehicle. We don't have work time. We need to be sensitive to the fact, again, that we have to comply with federal law and state law, and under state law, this exception does not always appear. Let's go on to talk about donning and doffing, and donning and doffing can be reduced these days to fairly simple rules, and that is if you have to change clothes at work, it's going to be work time. If you have the option of changing clothes at home, it's not work time. One of my colleagues prevailed in a recent case for the city of Mesa, Arizona, where police officers had the option of changing to their uniforms at home, and even though most didn't find it very appealing or practical to change into the uniform at home, because who wants to be on a city bus and have a well-intended citizen be quizzing me about what life is like as a police officer, or what can I do about my neighbor's cat? The court said you have the option of changing at home. We are not going to require that to be work time. But we do want to be sensitive to the fact that if you have to change at work, either because the employer requires it, there's a federal regulation, for example, in food processing that requires that, then work time starts. And of course, once you put on your uniform, if it's work time at work, then walking to the production area is work time. Waiting in line for the uniform is work time. And you'll have the same issue at the other end of the workday. Let's proceed, and we'll see that we've already discussed the circumstances to which donning and doffing is not compensable. We do want to be sensitive to the fact that this is probably one of the most recurring sources of litigation, because if you do require people to put on uniforms, it probably applies to everyone or a large group of employees, and you can have excellent fodder for a class action. And in fact, you have to wear a uniform. We need to be sensitive to the fact that a uniform can entail work and its maintenance. And if we look at the next slide, we will appreciate perhaps that we had a client who had an employee handbook which simply said that your clothing must be wrinkle-free, and they gave uniforms to employees, and they were wash-and-wear uniforms, and we can see by the last bullet here that if it's just a wash-and-wear uniform that you can put in the washer and the dryer and pull it out and give it a shake and wear it. There is no work time entailed. But the employee sued on the premise that wrinkle-free meant that the employee had to be ironed, that the uniform had to be ironed. And as it turned out, the supervisor, this employee, was a bit of a stickler on the subject and did challenge people if their clothing was not entirely wrinkle-free. Fortunately, as the case went on, it emerged that very few of the employees actually did iron their uniforms, and quite a few of them volunteered that if any ironing was done, it wasn't done by me, it was done by my other half, who did all of the family's ironing, so there was a little bit of an escape. But in fact, if you do have a uniform, particularly defined clothing, such as something that has a company logo, particular color, particular weight or design of clothing, and it is not of a wash and wear type, you do have to compensate an employee for the additional time. Let's turn to one more slide. As we approach the end of our program, we talk about suggestion systems, resolving grievances, charitable activities, generally not work time. Best example of this, just to illustrate the concepts, are prizes for employees who refer applicants to the company who become employees. It's a very effective recruiting tool. Send us your friends, your acquaintances, perhaps even the person you met in the checkout line at the grocery store. And if they're really qualified, we will provide you now $50 perhaps for the referral. And if that activity is voluntary and it's entirely voluntary and it's outside of regular work hours, and hopefully the time spent is very modest, you don't have to consider that to be work time. One exception there, your HR staff, which is usually engaged in recruiting employees, cannot be considered not to be working just because they're doing that outside of regular work hours, especially if there's a prize for that. And we are going to bring our program to a close with the last slide. We're actually going to be talking about sleep time. And you might wonder, okay, we got through the employee who fell asleep at the desk, 5 minutes with a head down, wasn't a very good scene, and we now know that we can escort that employee to the door and suggest that they go home. Hopefully the employee did not have sleep apnea and we don't have an ADA issue to think about. But sleep time is a recurring aspect of some employees' employment. I do a fair amount of work for children's homes in California. Some of them use what we call an awake model, a sleepover model of staffing. Others use an awake model where you have rotating shifts. But some of these facilities like to maintain continuity of care in a family-like environment, and someone may actually come and sleep on the premises. And here we can find the rules that really determine when sleep time is work time. The one thing that employers get caught up on, and this is why I wanted to introduce the slide, and I'll point it out, is the fact that for sleep time to be work time, you do have to pay for, it has to be part of a 24-hour shift. And that means if you want to exclude the 8 hours of sleep time, the employee actually gets 8 hours of off-duty sleep time. And with the possible exclusion of 3 one-hour meal periods, you otherwise have to pay for the adjoining 13 hours. Employers most frequently run afoul of this, and this is the constant caution in the arena of wage and hour, by trying to indulge an employee and say, hey, look, I'll give you afternoons off because all the kids are in school during the afternoon, and you want to go to the community college and take a couple of courses, or you just want to kick back and rest, or you want to ride your bicycle. But when you start carving out anything from that 24-hour cycle other than 8 hours of sleep time and 3 one-hour meal periods, you wind up corrupting the premise for excluding sleep time as work time. So again, I will end our program today with the cautionary note, be careful in the arena of wage and hour for favors you do employees, because you can discover that it comes back to haunt you. Probably a good rule of thumb in most of employee relations these days. And with that, Armando, I'd like to turn the program back over to you. Thank you again. Thank you, Replicon, for the opportunity to speak this morning. I hope the folks in the audience enjoyed the presentation. We'll take questions and answers in a minute, but I think, Armando, you have a few things to say about Replicon.
Yes, great. Thank you, Brian. Great presentation. So we're about to head into the Q&A part of the presentation now. So if you have your questions, please type them into the questions box. I already see that we have several of them, so we'll have Brian address as many of those as we can. Before we do that, I wanted to just spend about 3 minutes to tell people who are on the webinar a little bit about Replicon. So as I mentioned earlier in the webinar, we are the leader in cloud-based time tracking applications. and we are used by millions of users across the globe in order to manage their workforce attendance, also projects, programs, professional services, organizations, so a wide variety of project or time and attendance tracking needs. We have over 7,800 customers that are extremely diverse, ranging from many different size companies, from very large to very small, deployed throughout the world that we support in their initiatives. And when they come to us, they're looking for help with these key areas at a high level. So they're looking to have better insight into their workforce, into their labor cost is costing, where employees are spending their time, compliance help for managing HR or payroll-related compliance and ensuring that they stay compliant with the different regulations, which is why we're sponsoring this series of webinars, is to provide that education as well to our viewers. And they're also looking to automate the process by providing an automated system. They are able to automate their time and attendance tracking and reduce errors and create greater efficiencies. And this is a broad, high-level view of our time and attendance management solution. So at the core, we do have the time tracking and time collection component. We also support absence management as part of that solution. We provide cloud-based time clocks that can be used for employees to very easily punch in, punch out, and we do facial biometrics as part of that. We help provide scheduling support so that schedules can be maintained, and the compliance management aspect that I talked about just now. And our philosophy as far as capturing time is that really we empower organizations to allow employees to capture and record time from anywhere at any time if that's what they choose to do. Companies have different policies with regards to that, so they can definitely enforce their own policies. But for some of the things that Brian has talked about today, the fact that work time can be defined differently depending on a specific circumstance, we do provide that flexibility for employees to log in their time for places like their mobile device, any web browser, tablets, which are becoming more and more prevalent, as well as time clocks. And we have a very unique way of the way that we deliver time clocks. Essentially, we don't need vendor hardware. You simply use a tablet, and we empower that device to turn it into a time clock that can be linked to our software. So before we go into the Q&A, I wanted to let people know that this is part of an ongoing series of compliance webinars that we're pleased to bring you and that Brian has so graciously agreed to present for us. Today, as you've seen, has been on what constitutes work time. The next one in April will be on, well, now that you know what is work time, how do you go about recording that work time? And it's really not as simple as some people might think. As many of you on the phone are already aware, there are a lot of details that need to be addressed, such as how do you effectively do rounding, what kinds of approvals are managers entitled to make the time cards, how do you actually manage meal breaks? All of these are questions that people often have, and so Brian will be back again in April to go through those questions and provide some guidance there. And then we'll have some other, you can see the other topics here that we'll be presenting later in the year, and you're welcome to visit these and register for these on our website once they become available.